call the October meeting of the Rules and Strategic Planning Committee to order. Mr. Kalish, Clerk Kalish, can you take the roll, please?
Brewer,
Here.
Seep, Glassburner, Gentis,
Here.
Burke, Cosgrove, Frank,
Here.
Fleming. You have a quorum.
Thank you. And there was proof of notification
Yes, the meeting was properly noticed.
and the September 7th meeting minutes. Does anyone have a comment, correction? I will declare those as published, approved as published. And we will get into public comments, which correctly says they will be listed on the agenda for later meetings if we have any. Okay, thank you. Discussion and possible action, utilization of corporation council policy. I will open that up to whomever.
Yeah, so we've been kind of talking through this and we cannot find any other county that has a policy for the utilization of corp counsel. So Mike and I are going to work together to draft something. We've got some notes and some things that we think are relevant and important. So we will continue to work on a draft of that to bring back to the committee.
Sheriff Brewer, this is Bob.
Yes, Bob, go ahead, please. Mr.
So
Frank.
thank you. I'm curious why no other counties have that. I think it's a reasonable document. Are we just breaking new ground, or how are other counties handling that?
I would have to say we must be because we cannot locate that sort of a policy. And I do think it's an appropriate policy to have both for, for Mike and for all of the rest of us so that we establish a proper protocol on how things should be done. So I think it's great that we're doing it and, we'll work our way through.
One explanation for that could be that while not unique, it is not typical for a private attorney to be contracted for corporation counsel services. Typically, they are an employee of the county, and so the billing of it and the costs are not really a factor.
Mr.
Thank
Seed,
you.
did you have a comment? Excuse me, Bob. Mr. Seed?
No, I'm sorry. I was just trying to get attention.
Okay.
Fix my
Bob
mic.
Frank? Go ahead, Bob. Okay.
Well, I do have a comment,
All right, Mr. Seed.
Chair. In the past, and I hope that the tradition continues. Excuse me, I have gum in my mouth. Continues. Each county board member could contact or communicate for advice independently with the corporation counsel, and I hope that tradition continues.
Mr. Chair, that is our intent.
Okay.
Second point I have is that should, I think one of the things that should be ironed out is in the case where there's a personnel problem or an issue between a department head and a county board member or a supervisor, and the corporation counsel is accessible generally to staff persons. But in this case, if there's a conflict, there needs to be some sort of a trigger for preventing a conflict between the corporation counsel advising the county and advising the staff person, so that perhaps in that case there may be a third party legal advice requirement. So I'd like to have that question addressed, because I've seen that come up on one or two occasions in the past, and it's a rather awkward and cumbersome situation.
Mr. Chair.
Yes, Administrator Patch.
So I do believe that in that case, Mr. Seep, it should run through the administrator first. And the administrator can then determine what next steps should be, or HR director. In this case, I will be both. And then we would establish, at what point Corp Counsel gets involved and what that involvement would look like. Because there could be a number of factors in that situation. So there may be discrimination, harassment, an ADA issue. There are all sorts of things that could potentially be contributing to that conflict that may be more HR related than legal related. And then it would be put on to me to determine then how I would utilize Corp Counsel going forward to rectify the situation.
Thank you. And I think therefore it would be helpful if the administrator would provide a policy guideline so that the board has an understanding of those particular administrative decisions which are potentially going to be made. Thank you.
Okay, so we're working on it, is the answer here. It's new ground, apparently. Shouldn't be, but it is. I think it's probably, well, we've always done it this way kind of thing, so.
In the past, if I might add one point, in the past, if it was a personnel and labor issue, we referred those cases to a labor lawyer, and it was completely separate. There was a wall between the labor lawyer and the county's corporation counsel.
Absolutely.
We have not been doing that with the acquisition of a new and very capable corporation counsel.
Thank you. All right, can we move on? Discussion and possible action, county board rules review.
Again, this is an item that was brought before the board last month, and we are continuing to work through some of the changes that are required to be made to our board rules. We are also awaiting the rest of our surveys because I do believe that they will impact some of the items that will be contained in the new policy going forward. So we hope by next month to have an actual draft for you to review with the changes that we are recommending, both because of statutory requirements and operational need and requirement.
And you did mention the questionnaire that John sent out to all county board members, and we've only got 10 of them back. So
11 now.
11. Would like to see more. So if you haven't done it, I think all of you people have done it. So. Okay, thank you. Discussion and possible action, strategic and comprehensive plan review.
Okay, so this also was on the agenda last month. The comprehensive plan, I have gotten my hands on it, and I do think it would be wise for us to have a review of that with the entire board with Troy. I don't think people know what it is and they've never seen it, and it's a very large document to just throw out and say. So I would recommend that we maybe schedule Troy to come in and brief the board in its entirety prior to taking action, if you are all comfortable with that. And as far as the strategic plan, I also think after we get the new board rules written, that is an appropriate time then to review our strategic plan. And I would like guidance from this committee as to whether you want it to happen at this committee level, or you would like to schedule kind of an in-service workshop with the entire board to review it together.
Thoughts? Linda?
Well, the first
Linda?
one, I don't know if I'll get it all read, but the comprehensive plan, I'd like, if you can do it ahead of when he comes to review it, if we can have it on our iPads, because it's always is really hard when they're reviewing it if you haven't thought about it, so that. And the other one, I have to think about whether it should come through here. I think maybe it would be easier, but I think a workshop is a good idea also.
Ingrid Glassman.
Yes, thank you. So I don't think that comprehensive plan, I think you can find it on a website, but it's not, is it on PDF on our website, the comprehensive plan?
I think it is.
I thought the only way was to get it off that list. Okay, maybe I'm wrong.
Well, we can put it in a folder as well.
Yeah, and then my next question was gonna be, on the strategic plan. So when you say review it, are you saying to like update it or, okay? Because I know this committee is supposed to be reviewing it, I think, quarterly.
Okay.
So if that's different than that's just a review of like, where are we at on the work plan, that kind of thing. So I guess if you're talking something different, then maybe that's better for the whole board. I don't know for sure what you're looking to do.
Okay. So I wasn't aware that this committee did that on a quarterly basis, so that's good to know.
This committee didn't have meetings in the spring.
Okay. But you know, there are several items that I do believe we are moving forward on and accomplishing. And then I feel like because of our situational shift, there may be new items that this board would like to see or address, or items that they would like taken away. And so my question is really, you know, do we start here and do we make those recommendations here and then take it to the entire board? Or do you want the entire board involved from the get-go?
I
I've seen
personally
it done
think
both.
it should start here, because that was kind of the intent of putting these two boards together.
Okay.
And it would be a lot less cumbersome
Okay,
to just go with recommendations. I think having the entire 21 board could make it take a very long time.
okay, perfect.
Can I just say something?
You may, Ms. Dennis.
I know that's a lot to do. When we did the ethics review, we did so much each meeting, and that really seemed manageable. So I was just suggesting that.
She means that we did like a section.
Sure,
Yeah.
sure. And I mean, we could do that. We could take one or two sections of the not the comprehensive plan, the strategic plan, and just address those. And I could go in ahead of time and mark off the areas that we have accomplished. And if I have specific questions that I would like guidance on, then I can ask as we go through those. So that sounds great to me. That's what I was looking for, just some guidance from the committee. Thank you.
Supervisor Fleming.
Yeah, I just wanted to add that I agree as well. I think it's good to have it done here. It is part of our job to be doing that. And so we're starting here, and then eventually we could take it to the full county board if we felt we needed to get their input as well.
Perfect. I appreciate it.
Imagine that, people volunteering to take on work. So great. Great.
Yeah.
Mr. Z, what?
Thank you, Mr. Chairman. Just a protocol thing out of the way here as a matter of courtesy. I'm not sure how to, in an official meeting, how to address our administrators. Should it be Madam Administrator, or should it be,
Your Honor.
as we do, Mr. Chair, Madam Chair?
How about Administrator Pesh?
What would be the preference of the administrator?
I will answer to pretty much anything. You could call me, hey, you, and I. So whatever you're most comfortable with, Supervisor Seep is fine with me.
To continue though, a level of civility and proper decorum, I as chairman request you address her as Administrator Pesh.
Thank you. I don't think we need to vote on that.
Okay, thank you. Ethics policy review, discussion and possible action. I know we were kind of down the road on that, but we hadn't, of course, we took it section by section.
Mr. Chair,
Ingrid Glassman.
I'm sorry, this is to go back to that previous one. I had forgotten a question. So on the comprehensive plan, I think at last meeting it was brought up that we had those requests for proposals or the bids, and then we had agreed at this committee level that we were going to award that to Troy, but then that never got forwarded to county board. So I guess my question is, where are we at on that? Are we just assuming that we're going to be awarding it to him? Are we waiting for that action?
Well, and that's where I feel like we need to educate the board a little bit before we ask them to vote on it, because I don't think some people know what it is.
Mhm.
So that's where I was thinking, you know, do we bring Troy in to give a brief to the entire board, say, this is what the RFP is for, this is what it will look like, this is what we will do, and then have the vote so that people understand what they're voting on.
Okay.
Because I think there are many that don't.
The other part of that though was on the initial requests for proposals. it had a pretty strict timeline. And when they responded with their bids, they would then put in their own timeline. The idea was to have it done by, you guys remember? It was next year sometime, wasn't it? And obviously that's gotten delayed so much now. I don't know how much that's going to change his original bid and what we need to consider for timeline. I think we had been hoping to try to get that done prior to the next term. I don't think that's going to happen, obviously. But that's just another piece of it.
Okay, I can reach out to Troy and kind of get a timeline and see where we're at on that as well.
And in fact, Ingrid, one of the other bidders for that, responding to our request for proposal, were very concerned that they didn't get the bid and questioned that. And I remember Sean reaching out to them later. So it is concerning that we never followed through on it. Mr. Seat.
Yes, Mr. Chair. I think I would perhaps defer this question to, you may want to defer this question to Corp Counsel with regard to a couple of questions that I have regarding ethics. One, does the ethics policy apply to both board members and employees? That's question number one. And the second question I have is, I should be writing notes. I can't see my notes, so I have to rely on my memory. It will come to me, but that is an issue that I would like to see clarified. If not, should there be a separate ethics policy for employees? Well, this is the question that I had. How is our ethics policy aligned with, premised by, or rooted in state statutes with regard to ethics? And those are questions that I think need to be clarified and discussed. Some, Mr. Wendell, I think some behavior by county board members and employees is covered by state statute, I would think. And so are we merely aligning some of our elements of county policy with state statute, or are we amplifying it, making it more strict or less strict? Those are questions that I think are of important relevance. And perhaps Mr. Wendell would like to contemplate those questions before responding. But
I have a response, if not an answer. So somewhere in the vast pile of scattered papers that constitutes my office, there is a copy of the ethics policy with a big question mark written next to employees only or all officials. So as currently written, the ethics ordinance applies both to employees and board supervisors. My recommendation would be we put the code of ethics for employees in the employee handbook, because that's where it should go. And we have a different authority to regulate behavior of employees than we do for board members. So I do favor a division of the two policies. Regarding state statute, as it applies to elected officials, so board supervisors in this case, the state statute really only covers conflict of interest issues, financial interest, pecuniary interest, receiving things of value in exchange for official action. And so the code of ethics for the board supervisors is essentially going to be a set of behaviors and standards to which you all agree, separate from state policy, state statute. So The things in state statute, we don't really need to incorporate into an ordinance. We can do a citation to them, if that's helpful, but they apply regardless of whether or not we pass an ordinance for it. This would be for things that are not covered by the statute.
Is there, with regard to employees, is there anything in law, state law, analogous to the federal Hatch Act with regard to potential political activities or advocacy by employees?
Employees are not, at the state level, there is a direct analog, not so much for the county level because that would fall on us to pass. I believe it's policy, somewhere in the policy. I know certain personnel are already subject to policies that forbid them from engaging in political advocacy while in, on duty or in the course of their public employment. Other than that, just generally the conflict of interest statute. So you couldn't receive something of value, even an employee, and either perform or refuse to perform an action because of that.
Use of one's position or office or facilities for the purpose of advocating for a political view or candidacy would be, in accordance with what you're saying, inappropriate? Or would it have to be defined by policy?
I am not comfortable making a blanket statement on that, in part because it would be very much fact dependent, and in part because the rules would be different for a supervisor than it would be for an employee. If you were to ask my personal opinion, I would say that as nonpartisan officials, county board members should not, in their official capacities, endorse or advocate for any partisan position or issue or candidate. But that is something to which you will all have to agree to restrict yourselves.
I was more concerned about the employee behavior.
Employee behavior we can stop. Employees don't give up their First Amendment right by dint of employment. However, case law, statute all supports a greater ability of an employer to manage the behavior of employees, especially as it relates to when they're on the clock.
Mr. Chair.
Yes, Administrator Pesh.
I happen to have quite a bit of experience with this, being in the middle of some contentious elections prior to my time here. And the rule of thumb is when they're on county time, on county property, we can regulate what they do. If they are out in the public, not representative or representing the county in their official role, they have the right to free speech. So there's a very definitive line as to when and how we can regulate their behavior and their actions. Mr. Wendell did, I agree with him, a supervisor or an elected official. Now that is much more clear because that is, you cannot use your official position. You cannot use, you can't stand on the front lawn in your uniform and endorse a candidate, which I've seen happen. So
I'm sorry. Chair Brewer, may I speak?
You may.
So I have seen that using your uniform, people have endorsed candidates. So that is whether you're elected or appointed or you're not supposed to do that. Is that correct?
So, Mr. Chair.
Go ahead.
If you are running for office, let's say you're running to be a sheriff, then it's okay. But you can be in your uniform, your badge that says Richland County shouldn't be identifiable. So that's where I've found that line to be. You can be in a uniform as long as it is not an identifiable uniform because you're running for that particular office. Mm-hmm. However, there's some disagreement on this one. If, let's say, you are a sheriff and you want to endorse a specific political candidate, an attorney general's opinion has stated that they can do that because they are an elected official. And whereas if it were a patrol deputy doing that, it would not be allowable. So it's
That's
very
different.
case specific, and there are a lot of nuances to how that can work and what is legal and what is not legal. So even a policy still wouldn't cover every single scenario.
Yeah, okay, thank you.
I think this is a very important subject and it should not be taken lightly.
Who do you want to endorse, Don?
I don't want to endorse anyone.
Okay.
And I have not, and most board members have not involved ourselves in endorsement. And my issue here was more with employee behavior.
Yeah, thanks. Okay, I don't have the ethics document in front of me. I will allow the chair of this committee to handle that upon his return next month. So,
In one sentence, what does the Hatch Act prohibit? Mr. Wendell.
Laws could be defined in a single sentence. My job would be a lot easier. So generally speaking, laws provide, especially criminal or civil laws forbidding a kind of behavior, try to encompass 90 to 99% of the examples of that behavior in their specific language. But generally speaking, the Hatch Act forbids federal employees from benefiting from their position, whether that's through receipt of things of value, favorable treatment, and regardless of whether or not that benefit is tied to action or inaction. So you don't necessarily need to take a bribe to sign off on a permit. You can just get invited to a hunting trip or on a cruise or something like that, something that's very valuable and would not necessarily be offered to just a general member of the public. It's only offered specifically because of the position that you hold in the federal government.
And they can't campaign for any candidate regardless of party, company time. Is that correct?
Mr. Chair,
go ahead, Administrator Fish.
I have been subject to the Hatch Act, so I can tell you that it means that you will not engage in any sort of partisan political activity. You will not comment while you are a federal employee. You will not voice support for a candidate. You need to keep all of your actions non-political and nonpartisan. And if you are found to violate that, then you are subject to disciplinary action.
I think that's a good model for us.
Thank you. Okay. Discussion and possible action, determination of residency for county officials, and that I do have in front of me. And I know we just had a situation arise where a county employee, county supervisor, excuse me, moved out of her district, and so she ceased being a supervisor. But in my recollection, we had county supervisors move out of their districts and stayed on as county board members. So I will refer to perhaps Corporate Attorney Wendell to fill us in on that, or Administrator Pesh.
So let me first start by saying I appreciate being directed to look into this. This is one of those wonderful little examples of law where my interpretation was not wrong, but it was not the entire picture. And so really there are two questions that were raised by this recent event is when is a vacancy created, and then how is that vacancy filled? I was right in the first part. Vacancy is created the minute you move out of your district, or there are a number of other potential reasons for a vacancy to be created. So dies, resigns, removed, et cetera, et cetera. Those are in part listed out in Rule 20 of the rules of the board. And then upon examination of the rules of the board, that's where things really clicked as to where the issues lie. So again, the minute you move out of your district, your seat is vacant. A supervisor seat is vacant. So some of the questions that have been raised is, what is the responsibility of the official to report that they have moved? And those are things that we'll need to address. But then Rule 20, the one that spells out the vacancy creation, is poorly formatted. It comes down to literally somebody hit enter and it tabbed in, and it makes for a very difficult read. The part that I was missing is the how are vacancies filled part. And because of the organization of the county, the Board of Supervisors can determine how vacancies are filled. And in the rules of the board, it does state that someone who moves out of their district but remains a resident of the county can serve out the remainder of their term or until a replacement is appointed for them. And so your recollection is correct. And in that instance, that supervisor could have continued to serve. By the time we realized that and could have informed her, it would have been her voting to approve the minutes before her successor was appointed. So there wasn't a lot that we could do on that end. But moving forward, the board does have the ability to pick more or less however they want to fill these vacancies. As it stands currently, again, if you move out of your district but remain a county resident, you can serve out the remainder of your term or until your replacement is appointed. However, the rules in section 21, sub A, sub 3, sub B refer you back to Rule 5 for how vacancies are filled. Rule 5 governs the setting of the agenda. It also states that selection of the board are held in the same way that selection of members of the Committee on Committees and Highway Committee are chosen. Obviously, neither of those exist any longer, so that will need to be changed as part of the rules update. But that is where that stands on that specific instance. I would say that, if it is not clear cut, it would be more of a case by case determination for whether or not someone is out of a district or, we dealt with that some in redistricting, like my mailbox is in one place, but my actual house is in another. Generally speaking, wherever your bed is where your residence is.
It was my bed and my barn, different.
So, again, the interpretation was not complete.
Mr. Chairman.
Mr. Chair?
Mrs. Glassman, please.
So I read that entire article and I just want to clarify when it says okay, so it goes through all of the things that you mentioned about when they move out immediately, etc. But then at the bottom, it said who determines the residency of a municipal officer. So then it was like, but the county or the city or whatever can determine what residency is. So does that also apply to what you were just saying as far as like, I have 2 residencies? You mentioned that it states in there that it should be where you sleep, but if the municipality has the right to determine that, do they get to determine that as well? Or is it just in an instance like what we just had?
So it would, where you sleep is a rule of thumb. That's not a formal statute or law or
Okay.
policy written anywhere. I would caution against creating a policy that conflicts with a reasonable interpretation of what your residency is. So one of the cases cited in the article that was presented is that these municipal employees had mailboxes and apartments and things in the city in which they were supposed to reside, but their houses, their spouses, and the majority of where they spent their time was outside of the city. So in that case, that set of facts should be presented to someone, whether that be this committee specifically, whether it be finance and personnel, because if we're dealing with employees, whether it be the board as a whole, they would need to evaluate those facts and determine, well, does this qualify as residency for our purposes or not?
That was I guess that was the bottom line of my question. It does give us room to kind of go on a case by case basis, correct? And then lastly, with the previous supervisor, I know it doesn't really change it now, but I think that it should be communicated to her, this information, that, you know, it was a misinformation. She could have completed her term. I don't know who the responsibility of that would be, but I just think that's only right to let her know that according to the rules of our board, she could have served out the remainder of her term.
I would have no problem issuing such a statement. I just don't know how to get a hold of her.
Wendy, can just,
I don't want to belabor this. It's just that I read the whole thing. Then I got down to Rule 20 and it seemed to go against the whole thing. So, so if someone moves out and they can still do the remainder of their term, but the board could also start to look during that time for someone new. That's what you know.
So that gets to the subtle distinction between a vacancy and filling a vacancy. The minute you move out of your district, your seat is vacant. That is hard
whether you live
statement,
in
hard
your county
fact.
or not.
Whether you, wherever you move to, you are out of the district. What happens, and what I was getting at with the formatting, so the statement you're referring to, by moving out of the county, semicolon, supervisors who move out of their district but remain a resident of the county may serve the remainder of their term, is all awkwardly formatted, broken into two separate sentences, and calls back to the opening sentence of the rule. So what would happen is the vacancy is created. According to the rules of the board, that vacancy is immediately filled by the incumbent who moved out for the remainder of their term. So these should be separated out into separate, probably, rules, really. I'm not sure that we need a rule laying out some of the reasons vacancies may be created, because it may create a false sense. If someone meets one of the reasons under state statute, but they only read the rules of the board, they may think, oh, my seat's not vacant, but it is. So the fix to this is going to be part of the change to the rules of the board.
May I ask on that, would it make sense to just put that particular sentence down underneath the vacancy section, or the Rule 21, as far as like to fill it then? Because, and to your question, I don't think as a board we would then look for another, if you have the incumbent who's just going to serve out the remainder of your term, it's not like you would, are you saying you wouldn't post then, right? Like that there's a
I am
vacancy?
saying that is your decision. So,
But that's how I read this. And I mean, if they choose to, if they're saying, I still want to serve the rest of my term, in my opinion, the way it's stated makes it sound like you wouldn't need to follow that rest of that.
and
But I could be wrong. I mean, maybe it's just open to interpretation.
well, that's the problem. And then this is something that we should probably be able to eliminate that openness. So I think that warrants further discussion now that we've identified the issue. As to, all right, so if someone moves out of their district, the vacancy is created. What happens then? Do they continue to serve while we search for a new person who lives in the district? Do they continue to serve out the remainder of their term, and then, there's a new election and they're no longer qualified? That would be your decision as the board as to how you want to fill your vacancies.
Mr. Singh,
I would think that, well, first of all, with regard to vacancy of the position and continuing to serve, I can think of two precedents where individuals moved to another district within the county, and continued to serve till the remainder of that term, which time their vacancy became effective and someone else would have to run or be appointed to the position. we had two examples of that. One was with Betty Cook and forget who the other one was, but I know there were two. There's a certain nuance here, I think, with regard to the vacancy. If one vacates or one moves from his residence and out of his district into another district, and yet within the county, I think some would say or think that that is a different issue than one who would move from his residence and move outside of the county. Some would say, well, that's a little different. I think that is a question that we might want to address.
And those are actually answered extremely poorly in the rules of the board. So if you read Rule 20 as it speaks to this issue, vacancies on the county board are created in the following ways. And then by moving out of the county, period, that should be its own clause. If you move out of the county, your seat is vacant. And then the remainder of that sentence, supervisors who move out of their district but remain a resident in the county may serve the remainder of their term. That's nothing to do with vacancies. That's not talking about how a vacancy is created. That is talking about how a vacancy is filled. That's why that part needs to be taken out and put into the Rule 21, which then speaks to filling vacancies.
Then there's no section for if you move out of your district, but you're still in the county, because we just have by moving out of the county.
Okay, so that language would then need to be read. So by
But does that
moving out of the district or the county.
Does that have to create a vacancy?
Yes.
If you,
That's state statute. If you move out of the district that you represent, your seat immediately becomes vacant.
so then we just need to figure out how that, what our interpretation of filling it is. Okay.
So that's what I mean by the vacancy. That's easy. That's in black and white. It's how do we fill it that there's a lot of discretion to.
Mr. Chairman, just a quick comment. My personal feeling is if someone leaves their residence and moves out of their district and therefore out of the county as well, I think that is an entirely different issue. And I would be opposed to continuing their service if they moved out of the county, but I'd be in favor of continuing the policy as we have of allowing someone, depending upon how much time remains in their term, to continue serving the seat to which they were initially elected.
It was only because of stories like Mr. Seeps, people came up to me afterward and said, but I remember times when somebody and then at the last meeting being directed to look into this, I found the answer to those questions. So nothing about the policy needs to change to do what it is that you're saying you want to do. But it needs to be more clearly laid out in the rules. Because if I get confused reading them, then certainly I would expect others to be as well.
Mr. Chair,
Yes, Ms. Fleming.
it's also possible that whatever you're referring to happened a number of years ago, the rule could have been different at that time.
Could have been. Or nobody looked at the rules and just did it how they felt was right at the time.
Or there was no rule about it at all.
Okay, so more to follow on this. But, Mr. Wendell, if you would please communicate with Danielle Rubersdorf and tell her you could have kept on. So thank you for your service. It's awkward.
So I'm willing to take direction. The question would be for those who know her better, would that seem to be rubbing salt in the wound now after, or do you think that would help?
I don't know her better, but I just think that if we state, okay, listen, based on your situation, we really wanted to determine what the actual procedure should be, and this is what we found. And so based on our current rules, this could have happened. We weren't aware of that, but we wanted to let you know that we're going to be making that more clear in the future. I think any person would appreciate that information.
Has the vacancy been filled?
Yes.
No, it has not been
Not
filled.
at all.
No, it
That
has
was the
not.
other.
No, we have no takers for that one.
Well, then I think that we should offer her the choice of continuing her service. If she decides not to, then good.
Mr. Chair.
Good thought, right? Since we
Mr.
have,
Chair,
yes,
but she did resign, so how would that then work?
She resigned on the premise that she understood that she could no longer serve. Because, and that was some misunderstanding that apparently she gained from her presence on the board or from someone else. But if that were not the case, fine. But if she resigned because she felt that there was a rule prohibiting her continuance, and then I think she should be given the opportunity to say, there's a misunderstanding here. You had a right to continue, have a right to continue your service till the end of your term. If you choose not to exercise that right, please let us know in writing, and we will move forward to fill a vacancy. That's one direction I would think reasonable to consider.
yeah, I agree. I think that's what we probably should do. And if it requires another swearing in, we can do that.
And can I ask a question? If someone comes forward wanting the seat from the advertisement, how are we dealing with that?
Would need to go through the same nomination paper as though she had submitted an application. I would think that would be the fairest means.
Wait, the person who resigned has to go through the application papers too?
For this one case, I think that that's the fairest. To be clear, I did not advocate for her to submit a resignation, and I've never really been clear on why she felt the need to do so. I can only talk from my perspective, but I believed I was emphatic and clear in that she needed to take no action whatsoever. The vacancy simply existed. But it was 5-10 minutes before the start of the county board meeting. Things were a little hectic. I could see the opportunities for misinterpretation, but to Mr. Seep's point, if the resignation was made due to a misunderstanding of the facts surrounding it, I would think that this board would be able to take the action to waive that resignation or allow her the opportunity to rescind the resignation, kicking it back to just a normal vacancy, which can then be filled per the terms of the rules. So I don't think that a new swearing in would be required because she would have she would serve out the remainder of a term under the terms of the current rules.
But then that goes back to that question as if we have other applicants, are we doing it the way that we previously did it, where somebody who's already serving just serves as the remainder? We wouldn't have posted that vacancy, or is she going to have to get nominated and voted on with the other candidate, if there is one?
I think we cross that bridge if and when we come to it. Right now, with no other candidates, we simply.
When was it closed, though?
Right, so the application's closed Friday, tomorrow,
Okay.
October 6th at 4 PM. Anyone that has interest in doing it just needs to submit to me the items outlined in there. So in theory, if we were able to contact Danielle, we could, to make consistency between the process and kind of answer your question, Ingrid, is what if 5 people swarm in and say they want to be this county board supervisor, which I'm, not exactly sure that's going to happen, nor do I think we should rest our bets on that. But at any rate, I mean, we could simply reach out to her and say, if you would like to continue service, email Derek this information as I have to receive that, and then be present at the board meeting then on the 24th. And I guess she would be then in the pool with everyone else, but at least her information would be submitted. So this way that couldn't be called to question in terms of a procedure be followed.
I personally don't know that she should have to have that submittal date, though, if we're saying she had vacated due to, do you know what I'm saying? Like, let's say we can't get a hold of her and then she finds out in the end of next week, like, I think she should still be able to come to the,
So
I know we're getting into.
poorly updated nature of the rules actually operate to our benefit in this example. The one provision that specifically speaks to how a vacant seat is filled in the rules cites to a rule that is improper and committees that no longer exist. My interpretation, therefore, is that there is, at this time, no set policy on how vacant board seats are filled, other than the provision which is in Rule 20, which states that as long as you move out of your district but remain a resident of the county, you may serve the remainder of your term. So we will need to change them in the future, but as a solution to the case before us, that this format exists is actually to our benefit.
Mr. Chairman.
Mr. Z.
Yes, it's sort of in response to the thoughtfulness of both speakers here. I vote for common sense here. It appears to be the fact, that she was elected to this position, and therefore, in accordance with what we've all said here, she is entitled to hold that position until end of term. And it is her position for the taking, and it's her position to give up. She gave it up under perhaps some misunderstanding, and until we receive some further communication from her in response to our informing her that she does have a right to continue to serve, and please advise us by such and such a date. Therefore, we could notify whatever applicants have sent us that there was an error in procedure and that the position is not open. It's going to be continued by the present elected position who has a right to hold the position. Just voting for common sense here.
Mr. Chair,
Yes, Administrator Pesh.
I hesitate to take any formal action on this at this point until we research it further. I just keep thinking in my head, if somebody were the president of the United States and they resigned and then they changed their mind 3 weeks later, they wouldn't just say, oh, just kidding, you can have your spot back. And so I'm not saying I agree or disagree. I think we should probably consult maybe Andy Phillips at WCA to make sure that whatever process we do decide to utilize and move forward with is legal and proper, rather than operating on what ifs and could be's. And I just would feel more comfortable from a liability standpoint if we had certain response. And that's just my opinion.
Yes, Mr. C.
I very much appreciate your circumspective view of this. I think it's, however, in some respect, not analogous, because the reason for resignation here comes into play. The reason that she resigned was because she thought she was supposed to resign because of a certain rule of the county. Now, if the president resigned, if there was a like rule there, then he might be entitled to reinstate if he resigned for the same reason, having moved to a different residence or to a state where he's not eligible. Whatever the case may be, I don't think that question of the resignation and the reason for the resignation in his case is analogous to this case. And I offer that slightly different dimension merely out of respect for your thoughtfulness.
Okay. Else want to weigh in on this?
Mr. Chair,
Ms. Fleming,
my question is, does she still live in Richland County?
that I don't know. Do we know? Anyone know?
I believe she does. I can't say that for sure, but I
had heard
believe
she had
so.
moved out of the county. That's why I'm just questioning.
I thought she moved with her mother who lives near.
That was the last location of her that
Maybe
I
had this conversation.
According to our policy, it doesn't matter where she's living.
It does.
Well, it does.
That's live in the county now. our poorly worded policy says she has to live in the county.
I guess, Mr. Chair, this is something that we're going to need to hash out sooner rather than later because you are all up for election here in a little bit. And I don't want issues of residency and how we determine that to fall on shoulders of 50 different people when we're all taking out nomination papers. And I guess, determining who determines who's a resident of what nomination papers and that sort of thing are a different kind of animal. But when it comes to even just the logistics of, okay, what am I supposed to do as the county clerk? How do I advertise it? What do I do? This needs to be much more thought out and concise and clear because it's not, and we see what it's doing now. So I think the question is how do you folks want to fill your vacancies? I think we've established that a vacancy is created when someone vacates a district in this case, but then how do you want to move forward? And I think this kind of goes back to a review of the rules in itself and why wordsmithing this right here on the floor, I don't think is a clever idea. I think it does need oversight by other Andy Phillips, if you may, but I just say that we are going to have to address this, and I know there's other rules of the board that need to be fixed, but this is one that maybe should take some precedence because it's going to be an issue here in a few months when we talk about residency elections and all that stuff, and Lord knows we don't want to mess that up. So let's have it fixed before then.
Yeah, thank you, Clerk Kalish, for your comments, and I agree, we need to do it sooner than later. Okay. So more to follow, and discussion and possible action, transfer of Education Standing Committee duties to Public Works Standing Committee. Administrator Patch.
And so the Campus Reconfiguration Committee entered a resolution recommending that the Education Standing Committee no longer be in charge of the campus proceedings due to the fact that at this point there is no educational programming occurring, and it is really more about the structures and the actual buildings. And so they have asked this committee to approve moving the campus to Public Works.
Comments? Linda? Comments?
Well, I have a education meeting Monday because I asked you whether I should have one because we have resignation and extension. And since we still are handling that, so we are having one this Monday, and I did put on the agenda, a discussion about this, but this will just answer that question. I guess my question was, it seemed to me that shouldn't have come from the reconfiguration. I'm just thinking legality, not that I'm against this proposal. It seems like the reconfiguration committee is not an official standing committee, and that this should only have come from this committee and not from that committee because they're not an official standing committee, and the official standing committee has things in our thing of what we're supposed to do. I just was wondering about that. So that's just a point of reference. And then the other thing is, we do have a directive in the education committee to be have the county be an educational and cultural center. So I think the Public Works should take that on as a directive as well, because that's part of the education committee's directive. They had the buildings in that, the food service and extension. And then I assume you're moving extension to Public Works. That was what are we going to do with extension to make sure they have a good, reliable committee and honor their, one more thing. In the past, since there's some, and we have to, the bills where it used to be and what was happening at the campus used to come through me and the committee, and that got sort of, in June, got sort of messy. And so just want to make sure things are done legally so that we're not out of statutes and that we have a good transition. Does that answer to my questions?
Nope. So I believe it was just a recommendation. I don't believe it was a formal action from the reconfiguration committee, but they thought it was appropriate that it be brought here for the request.
Yeah.
So that is how that occurred. As far as what happens with extension, I do not envision extension remaining under Public Works. I believe it is for this committee's discussion as to where extension would best fit. I have seen them co-located within the zoning and parks, or I'm sorry, land conservation, because they have some common interest there. There's some commonality with the agriculture. So that is an option that we could relocate them into that committee. And then Public Works would take on the additional. I would recommend against Public Works being responsible for culture. I think that maybe is not something that would tie in there, but maybe would tie in with the extension piece of it. And that's something that we could explore going forward. And this all is really kind of playing in with the whole reevaluation process that we're doing right now anyway, as far as what committees are making sense. I think we have already seen that there's some feedback that there are those on the board that feel like some of the committees right now don't make sense. Things don't go together. And so I think this is part of a more broad discussion to go forward. So I do think at this point, we can leave extension where it's at, underneath education for the time being, and move Public Works under, or move the campus under Public Works until we decide as a board, till you decide as a board where you would like to see these other pieces go. Right, as John's adding, that's why we want the input from the board as to how you're feeling, what you're seeing, what you think makes sense, all of those things, so that we can really look at that structure and streamline it even further and make it more efficient.
So then I have one further question on that, because I'm sorry I missed the last reconfiguration committee, but I plan to be at the next one. And I know that Steve Williamson is chair of the Public Works, and that one of the problems, I've seen under our current thing was that we were supposed to, if we were on this committee or on the finance, we were supposed to go back to our other committee and report what happened. And I think none of us were putting that on the agendas, that we're not following through with that. So I see the same thing. If the reconfiguration committee and the Public Works are both having the same goals, I think you need to have some sort of proper communication between them. Does that make sense?
Yep, John.
John Holcomer, just interim administrator.
So just one of my thoughts on that, and it's in looking at other county boards and their structure, and something that I did as a mayor. We don't have that many committees, the standing committees, and we could have every committee chair at a county board meeting give a 2-minute update on what occurred since the last board meeting. And I think that would be good. I mean, our effort here is to try and increase the communication and get the committees and the board members more familiar with what's going on countywide, and not just, Candace mentions a lot about the silos that are out there, and there are silos. We want to break those silos down. So it's really in an effort to increase the communication. So that's one thing that we're considering and may propose. And I would say, in addition to that, one of the things that I like to do, and I'll use human services as an example. I mean, how many times, even since I've been here, that Trish does, somewhat of a report to the board or to the committee, and those types of things. They're already doing it for the oversight committee. Why not rotate department heads through the county board meeting as well, and have them do just a short update? And I always tell the departments that it's good for the board to see you other than just at budget time when you're asking for money or positions. So I think those short reports would be very, very helpful.
May I, Corp Counsel Wendell, do you have language prepared to change the committee structure?
It would not take long. It's pretty much just.
I will ask for a motion here to do just that, transfer education committee duties,
Wait, not all of them then.
with the exception of the UW extension. Well, we don't want culture over there in Public Works, I don't think. Exception of,
So the exact
cultural.
wording is that the committee promotes the campus as a higher education and cultural center for Richland
Right.
County.
Right.
And you would keep that?
That for right now until we get
Yes,
everything
absolutely.
more organized.
So
So
Clerk
transfer.
Kalish, you have this motion now clear?
Are you asking me to write it? 'Cause- So a motion to transfer, can we just say, transfer, duties of the all duties of the education committee with the exception of, those relating to the campus facilities? Or, I'm saying that backwards, sorry, other way around.
So it's sections B, D1, and D2 specifically. That's all the budgetary stuff, oversight on operation and maintenance, and then the food service stuff, which is
Okay, so do we have it now, then? Have we,
I'd
have we
like,
captured it?
So,
Okay. Do we need to restate it?
okay.
oh, this is great. All right, motion by who? Cosgrove? Second by who? Marty Brewer. Okay, to transfer duties from the education committee. They were B1, D1, and D2. I don't have that document in front of me, so
B, D1, and D2.
B, D1, and D2. So we're going to transfer those duties to the Public Works Standing Committee and leave the rest with the Education Standing Committee right for now.
Except those relating to the UW Extension Service.
wait, that's not, wait.
With education, right?
D1 and D2, I don't know what. they
So,
are.
so B is monitors the actual versus proposed annual budget and funds managed by the Agriculture and UW Extension, UW Platteville Richland Maintenance, and UW Platteville Richland's Food Services departments on a minimum quarterly basis. So if we want extension to stay with education, we need language in there exempting that part from the
Right.
overall section B.
That didn't make that clear.
That's what I was trying to clarify. So it would be moving the authorities found under sections B, D1, and D2, except those as relates to the UW extension to the Public Works Committee. That gives all budget for maintenance and food service, and then oversight and advice authority over maintenance and food service to the Public Works. Everything else stays with education.
Okay, are you ready to vote? All those in favor signify by saying aye.
Aye.
Aye. We lost Bob a while ago.
Right.
Do we still have quorum without Bob? Okay. Against, say aye or nay. All right, the motion carries. Future agenda items. Yeah, we have enough. All right, motion to adjourn.
I'll make a motion to adjourn.
Fleming, seconded by Glassbrenner.
Okay, so this isn't on the agenda and we're done, right?